for being here. So we'll go ahead and quickly get started. Just on behalf of the Greater Bloomington Chamber of Commerce, I want to thank everyone for tuning into this webinar. These changes affect businesses, large and small, including nonprofits. So I'm very happy that we have two very engaged members that are experts in this area and agreed to be here today to present. So first off, we have Chris Schrader, who is president of Schrader and Associates, a full-service HR consulting firm focused on helping businesses excel and grow. Prior to starting his company, he worked for several firms in the publishing industry for more than 25 years, holding leadership positions in operations, sales, finance, and accounting and human resources. We also have Catherine Samara, who's a highly accomplished attorney with a strong background in employment litigation, employment counseling, and employee benefits. She earned a JD from Pepperdine University School of Law. She earned a BA in English and Political Science from Indiana University. She provides advice and counsel to employers on compliance with federal, state, and local employment, equal opportunity laws, and benefit laws. She represents both employees and employers in state and federal courts, as well as administrative agencies, with complaints involving claims of discrimination, harassment, retaliation, and wrongful discharge. Thank you again, Chris and Catherine, for both being here. Before we get started, I just wanted to quickly tell our listeners that we are leaving time at the end for questions. So if you do have questions, go ahead and enter them into the chat area. Also, I want to remind everyone that Chris and Catherine's descriptions of the rule and issues surrounding it are informational in nature, and this is not to be construed as legal advice, and responses to webinar attendee questions will not create an attorney-client relationship. So let's go ahead and get started with Chris.
Thank you very much, Ann. All right, I'll try to, mindful of people's time here today, I'll try to close the gap. If I move further quickly, I'll remind the attendees that this is being recorded. So we're going to move through a couple of items here. First, I'll give you a level set. How did we even get to this spot? The new rules affecting employers, Catherine will pick that up, as well as what employers need to do now, and then we'll move to a Q&A. So first, we are talking about the Fair Labor Standards Act, 1932. This legislation goes all the way back to the New Deal. That basically established the 40-hour work week, established child labor laws, the minimum wage, and created overtime provisions for the first time, which is the base wage times 1.5 times. That is one of the key elements at play here, that wage premium tied to overtime. They also created exemptions from overtime provisions, and these were specific roles that they recognized, Congress meaning they, recognized and thought that these were substantious enough and had enough control that they would be exempt from this. It is this particular classification that has grown substantially in recent decades, in particular after the 90s, the addition of the administrative exemption, which represented the largest growth of exemption. This also created at the time a duties test, which is very rigid and was designed to ensure that few people or few roles would be able to get this. It also created the salary basis test, which meant was the wage paid consistently and regular regardless of the hours worked. So these roles totally unshackled from the clock. The president directed the DOL in March to act on this particular issue, and so the president sent a memo to Secretary Perez directing him to modernize and simplify the overtime exemptions, and in particular, the rules were to be changed to make more workers eligible for overtime. So that was an express directive from the president. The DOL then proposed a rule and opened a comment period, which is required under law. They received over 270,000 comments on this particular rule during the period running from July to September of last year. This was one of the most heavily commented upon rule propositions that we've seen probably in the last 30 years. In the end, there was not much of an impact except on the salary floor, which is what we're going to be talking about today in substance. And the new rule was published on May 18th of 2016. That includes the minimum salary floor change that takes effect on December 1. So at this point, I'm going to turn it over to Catherine to talk about the new rules.
Good afternoon, everyone. I think before we actually get into what the new rule is, we need to look back just briefly at what the rule was prior to this new regulation being proposed by Department of Labor. There have always been exemptions for people who are not subject to overtime, and it's not a one-size-one-fits-all exemption. Instead, you have to look specifically at the job that someone is doing. So it's very important to have job descriptions, and it's also very important to make sure that the job descriptions reflect what the employee is actually doing. So the most common exemptions are what's called the white-collar exemptions, and these are generally referred to as executive, administrative, and professional exemptions. Now, for an employee's position to fall within one of these exemptions, they basically have to meet 3 prongs to a test, and that is the position has to be paid on a salary basis, the position has to be paid a threshold amount, and the position requires the performance of certain duties delineated for the specific exemption, and the position requires certain levels of discretion, also specifically delineated in the exemption. So one of the key things to keep in mind is that this test always has had 3 prongs. It's not just about the salary level. For someone's position to be exempt, they have to meet all 3 prongs of the test. So what are the new rules and what has changed? The first test hasn't changed. The person still has to be paid on a salary basis. The third prong has not changed either, and that is that the person's job still needs to require certain duties and certain discretionary levels. What has changed is the threshold amount. And as you can see on our slide, what has been raised from $23,660 annual salary to $47,476. This basically reflects to what was $455 a week to now $913 a week. The next part that's important with the new rule is that one of the other exemptions, which is the highly compensated employee, that minimum threshold level has changed. And keep in mind, with the highly compensated employee exemption, there's a lessened test with respect to the duties aspect. So again, there's still the requirement to meet all 3 prongs, that the position's paid on a salary basis, although with highly compensated employees there's a little bit of a difference in terms of how much has to be paid on a traditional salary basis as opposed to commission or bonus, and they have to meet certain duties, and it's a lessened test for the duties for a highly compensated employee. The amount in the new regulation for highly compensated employee was changed from $100,000 a year to $134,000 a year. So in order for someone to be classified as a highly compensated employee, they now have to be paid on an annual basis $134,000 a year. A big part of the change that I think a lot of people were concerned about is that these amounts are going to automatically increase. Part of the concern with why the regulations needed to be updated were the fact that they hadn't been changed for so many years. And the Department of Labor, to address this point, wanted to put something in so that this wouldn't happen again. So they're going to look at what the percentile of salaries in the poorest census region and will update those amounts, the annual salary amounts, every 3 years, and that will begin in 2020. Now, one other component that's actually, I think, appreciated that people were looking for is that an employer can use non-discretionary bonuses and incentive payments to satisfy up to 10% of the salary amount, as long as those amounts are paid on a quarterly or more frequent basis. Now, do the exemptions apply to everyone? No, and this hasn't changed. There are still farmers and family businesses that are not subject to the overtime requirements. Elected officials are exempt. Freight drivers are exempt. And then there's also an exemption which we haven't spoken about, which is called the learned professional exemption. And this basically exempts lawyers, doctors, and teachers from the exemption for overtime. There's also an outside sales person exemption, and these persons truly have to be outside salespeople. They can't be salespeople working in your office. They have to be working off the premises of your business. Clergy roles are also not subject to the minimum salary amounts. Briefly, just wanted to talk about the teacher exemption. That's one that seems to cause a lot of confusion, and one thing that was added in is that there is an exception for academic administrative personnel. So I think the idea was they're going to get to a point where persons who are working in schools who are not necessarily teaching are going to end up potentially, as a result of these threshold amounts being increased, being paid more than teachers. So what they did is they said there's an exemption that if you have administrative personnel that help run higher education institutions and they're being paid at least what a first-year salaried teacher would make, then they too will be exempt. And I think that was to address that concern, as I just said, that they didn't want the administrative personnel to be making more than what the teachers were. Now, what organizations are subject to the Act? The Fair Labor Standards Act pretty much applies to any business in the United States, and that is any business that's engaged in interstate commerce that makes at least $500,000 a year. So the big question comes with respect to not-for-profits. Are they included? And they are included. Not-for-profits become a difficult analysis because what happens is there's what's called the enterprise coverage, and that's what I just said with respect to the $500,000 in annual sales. If for a not-for-profit to fall within that category on the enterprise test, they would actually have to be involved in a commercial business. So if your not-for-profit has a gift shop or something where they're actually selling merchandise and they're selling at least $500,000, then they will be covered under the Fair Labor Standards Act with respect to the enterprise coverage. This normally doesn't happen. So generally speaking, not-for-profits are not covered by the Fair Labor Standards Act, but then, and this is an odd way that they've done the law, individual employees can still be covered under the Fair Labor Standards Act. And the problem with this is that the definition is so broad as to who is engaged in interstate commerce that it pretty much today applies to anyone. So they use as examples if part of your job is making out-of-state phone calls, sending mail or electronic communications, ordering or receiving goods from out-of-state supplier, or even having credit card transactions or performing accounting or bookkeeping for such activities, that individual employee is covered. So it's not correct to think that simply because the not-for-profit is not covered by the Fair Labor Standards Act, meaning that they would not be subject to these new rules. What happens is the individual employees are actually subject to the Fair Labor Standards Act and are subject to these rules. So what this entails is you're going to have to look at what each individual is doing, and if in fact what their job requires them to do covers them under the Fair Labor Standards Act, then in fact you will need to be in compliant with the new exemptions rule if they're working over 40 hours a week. I think, and we're going to go back and Chris is going to talk some more.
You're going to handle this.
Oh, sorry. So with respect to what employers need to be doing right now, as I briefly mentioned before, you need to make sure that your job descriptions are up to date. And it's very important because the job description is what the first item is that the Department of Labor will look at. But also make sure that they're correct, because once the auditor comes in and looks at your job description, the very next thing they're going to do is to interview your employees. And if they interview your employee and your employee's never seen the job description or gives them a completely different description of what their job is, then in fact that's what they will use to determine what the job is and what duties they're doing and whether or not they fall within the duties test, which would make them exempt. So you also need to reevaluate the roles to determine whether or not you have the proper classifications. We are certainly in a position now where, because this has come to so many companies' attentions, we're now looking closely and discovering that, in fact, a lot of people were probably misclassified to begin with. And I think some of that confusion occurred by the fact that there seemed to be a belief that as long as someone was paid on a salaried basis and they were making a certain amount of money, they were not entitled to overtime. And this was just an incorrect understanding, because in fact you always had to meet the 3 prongs, and that is not only the threshold salary amount, not only the salary basis, the threshold amount, but you also had to be meeting the duties test as well. The other thing that you're going to need to look at is you're going to have to make a determination from a business perspective of whether or not those people who may, assuming they fit within the duties category, that their salary level is below the floor amount now. As a business, you'll need to make a determination in terms of whether or not it makes sense to simply raise them above the floor, or to start paying them on an hourly basis and making sure that they are paid overtime for any hours worked over 40 in 1 week. Now, there's lots of different ways that this can be done, and it needs to be based on your business needs. So you certainly can take a look and determine whether or not, from an economic standpoint, if you have someone who is only working maybe a couple of hours over 40 in a week and it's not very frequent, it may make sense to just move them to an hourly basis. If you have someone that is working significant hours on a weekly basis over 40, then it might be necessary to either bump them up or figure out a way to make it either by hiring another employee or lowering that person's salary to account for the fact that they will now be entitled to overtime, to make sure that that can work from a business perspective. One thing that you're going to need to do, and fortunately the Department of Labor did give us more time than I think people had anticipated, so we have a few months before this is going into effect. But a good idea is to start tracking people's hours today, so that will help you make a decision, because right now a lot of your salaried people, you don't know how many hours they work a week because they're not keeping track of them. So unfortunately, if you talk to them, everybody works 50 or 60 hours a week. Everybody says that. But in fact, you need to look at what they're actually working in order to make that determination.
Catherine's point is very well taken. I'll tell you my personal experience. 2 times I've taken employers through situations in which a whole class of workers were improperly classified. So we had to take them out of the exempt role, which they were improperly in, and put them into the non-exempt role. In both cases, the employees were very upset. Needless to say, the thoughts of losing the flexibility was one of the primary concerns, but they also had an economic one. They told us flat out, you will never be able to afford to pay us overtime because we're working 50, 60 hours a week. This will break the company. And so I went through an exercise over a series of 2 months, and we tracked their time. I also wanted them to be able to build the habit that it takes to punch in and punch out and punch in and punch out. And every hourly person knows, but exempt people don't have the habits to perform. Lo and behold, after those months, what I found out in both cases was that neither groups were working exactly 40 hours. In fact, the average was only 39. So Catherine's point about perception and reality is very well taken. That's why it is important to work off of a data set. But you also have to take into consideration the ebbs and flow of your business. Between now and the end of November, or mid-November, quite frankly, is this representative of the flows and demands within your business? Is this really normal, this period you will be measuring in? If it's not, if this is particularly slow or particularly busy, then you'll have to take that into account in figuring out what your hours are. But this is not going to be necessarily easy. The point I want to make now is that communication is critical, and you need to put serious thought into it. One of the things that I think is not going to work is a statement that the government made us do it. That simply won't fly. The worker anxiety closet is going to be jammed packed. Usually when workers hear about no rules, the first thought that runs to their mind is not, boy, this is going to be great for me. Most people think when a new rule comes down that it's actually going to cut against them. So here are some of the questions that you're going to get. Will I get a raise? Will I get a pay cut? As we work through different ways to do this. Will I lose my access to email? This is an important one. Most employers are not aware of this. The Wage and Hour Division has taken the position and has won in court on numerous occasions that an employee who is non-exempt, reading email and working on that email, thinking about that email, acting on that email at home is performing compensable work, right? So this is one of the things that you're going to have to consider. When a person is in an exempt role and they're properly classified and they're paid the minimum amount and everything like that, you don't worry about this issue, but you do if they're hourly. Here's another one. If I punch a clock, am I demoted? The fact of the matter is most workers in the U.S. regard progress from an hourly role into an exempt role as one that shows they're moving ahead in their career or they're moving ahead in their station in life. And so you should not be surprised at all to find a lot of concern around that. And then what, of course, does this mean for my career? What are the implications for my development? All of this is going to come to the fore and has to be taken into consideration when you're thinking about what to communicate to employees. And so here are some of the things you need to start thinking about now, separate than the communications. How will workers react to less flexibility? Hourly workers managed by the clock traditionally have less flexibility and give, if you will, from the employers because there are costs associated with that. You manage hourly workers in a way very differently than you manage exempts. How will workers react to the clock punching itself, the actual act of that? What are the implications for future pay increases? You know, one of the things that's happened here with this automatic opportunity for an increase, right? Because there's no guarantee that an increase would occur, but they've now put it on a permanent escalator. And we didn't have to worry about this before in business. Our costs of human capital are the highest cost of operating the enterprise. And so we've never thought about being pushed necessarily in that direction on the exempts, but that's now going to happen. So if you know costs are going to go up in 3 years no matter what does that imply what you do in the intervening 3 years? What are the implications for advancement? What are the implications for organizational design itself? What are the implications for compensation strategy and design? All of these things get called into question in a very serious way. And I think, quite frankly, there are strategic implications. For instance, how many managers do you actually need? And this is why I pose this. One of the things I believe that has happened over the last 20 years, as more and more roles have qualified for exemption and more roles were treated as exempt, as Catherine said, where they should have been or not, but that was the actual environment people are working in, we haven't paid a whole lot of attention at the management level exactly what they did with that time per se. We never approached them in thinking about efficiency or effectiveness the same way we would have applied to the logic of the hourly workers. And so I think we need to put that into consideration. I think we need to challenge some of these basic precepts. You also have to think through the implications for recruiting. What have you been saying to the outside world about attracting people to your roles, and how does that need to change? How do you handle wage compression? Wage compression is what happens when your wage structure is set and then forces move floors up faster than the median moves, perhaps even faster than the means to do it, right? So if you have X amount of money in your budget to comply with this law, and you do, that means you have X amount of money unavailable to do other things, and it's reasonable to believe that wages would be part of that. So what happens when wages start getting tighter and tighter and tighter, and the difference between what the roles deliver in terms of accountability, in terms of results, narrows also. That can cause workforce conflict. What do you do if you can't afford the overtime? Do you use part-timers? Do you use independent contractors? Do you change how you are delivering goods and services to your clients? Does outsourcing make sense? Do you just move it entirely out? I was talking to a colleague who works at a larger company, and he said one of the things that this had kicked off in their company was an evaluation of the work done within the enterprise. And he said if it's rules-based, and outcomes are known and can be measured, then that is done at the lowest possible cost or outsourced entirely. If it involves strategic decision, if it involves waiting off different opportunities, if it involves cost or profit to the organization, then they're going to hold that internally. But that's just an example of what I mean about really rethinking how does your enterprise operate. Can technology make a difference? In the next 5 years, we're going to see a huge increase in artificial intelligence moving primarily into roles held by these types of positions, white-collar professional service roles. So can that technology make a difference? How much does that technology cost when you compare it against the inevitable cost increase of salaries 3 years from now? You need to consider, does a salaried non-exempt model with an agreement make sense? Catherine alluded to this earlier. To the extent that a person's going to work overtime less than 50 hours and their schedule can vary, and some weeks they may not even work 40. You can structure what's called a BALO agreement to put that into place. There's also a model that is perfectly acceptable called the fluctuating work week model. Does that make sense? Now I have two key cautions about both of these solutions. Both are available, and neither should be structured or tried without counseling from someone that knows how to build them. This is not something I would go out to Google and try to figure out. Learn what it means, yes. Build it and make it work legally, not so confident. So what are your choices? What are your choices? Well, you basically have 6, right? So you can increase the salary to the new floor and keep the worker exempt. And let's face it, if you've got somebody in your company who's making $46,000, $47,000, $45,000, wherever your threshold is, quite frankly, it may be worth just a couple of grand to shove them over the line and then buy yourself some time to 2020 and see how that plays out. You could convert the non-exempt to those a little or no overtime, treat them as salaried exempt. You can convert the non-exempt with predictable overtime, pay them salaried non-exempt, bake that in, set the hourly wage low enough so it doesn't drive compensation cost up. That's BALO. You can convert the non-exempt, those in predictable overtime, as salaried non-exempt, and distribute the remaining work to somebody else, right? So if you've got a job and it's driving a manager nuts, and let's face it, part of the reason why exempts work all these hours is because they're also doing a fair amount of non-exempt work. Does holding the exempt work in the role make sense, and then bringing in a non-exempt part-timer to absorb that work at lower cost make sense? We haven't thought of that type of job sharing model before, but I think this rule now calls that concept into question. You can also convert them to non-exempt and absolutely forbid overtime. That's another way to do that, although if they were working a lot of time anyway, there is probably a good reason for that. Your business probably needed it. And of course, you could just convert them to hourly and pay overtime. Here's the key thing to remember. Whether you are paying them salary non-exempt, whether you're using fluctuating work week or anything like that, if they are non-exempt regarding of the pay methodology, you are required to keep daily time records and required to retain those records. None of these solutions relieve you of the burden of those two things, right? That's the key thing to remember. If they are non-exempt and you're paying them on salary method, you are still required to collect the time. I can't emphasize that enough. So I think we compress this enough to be able to take some questions.
So it looks like some of you have typed in questions, so we'll go ahead and start with the most recent. Can offering comp time offset the accrued overtime? Is the comp time earned at 1.5 times more since it's overtime?
Comp time is actually a concept that should not exist in the private sector. It is only applicable if you're dealing with public employees. So generally speaking, it is not legal to refuse to pay someone overtime and instead give them comp time for a private employer. And again, understand everything that I say, I'm speaking in generalities. I'm sure someone could come up with some example at some point that would contradict what I just said. But generally speaking, comp time is a public employee concept and does not apply to the private sector. That being said, if someone is a public employee and there is a comp time policy, then what you do is it's just hour for hour. So if someone works, it's not an overtime concept. If someone works more than 40 hours a week and then earns 10 hours of comp time, they can then use that in a different week, and it's just with respect to just a number of hours. So it's not with respect to the overtime formula.
The next question, what percent of time needs to be spent doing something such as internet ordering and paying out-of-state bills for the employee to be considered doing interstate commerce?
The threshold around interstate commerce was set at a very, very low bar. As a matter of fact, this has gone to court numerous times, and every time it has, I think they've actually lowered it. It's very clear, if you look at the decisions, they really intended this to be almost as if single instances. I think that's the best way to think about this. It isn't like other pieces of regulation where you might see certain activity thresholds or something like that, right? So this rule we're talking about with a minimum salary threshold, obviously if somebody's paid over that minimum salary threshold, this is a non-event for people in those roles. But I would not try to hang my hat on the act not applying to me based on a volume of work done over state lines.
Do these requirements apply to individuals in any size of business by number of employees?
The requirements apply to anyone who is subject to the Fair Labor Standards Act. And going back to what we spoke about earlier, the Fair Labor Standards Act is such a broad act. It covers pretty much all employers. Now, it's not true. There are certainly some that you can find that it will not apply to. But any employer who has more than 2 employees and you're making more than 500, I'm sorry, it's not just a profit, it's activity, $500,000 in activity, then you are subject to the Fair Labor Standards Act. So there's no threshold in terms of the number of employees. If this would make a difference only if you had, for example, a one-person business, then you wouldn't need to worry about it. But generally, the Fair Labor Standards Act applies to almost every employer there is. I'm sorry, should I read it?
Yeah.
The question is, please list again the 3 prongs test. And I'll tell you briefly again what it is that I said in my presentation, which is the 3 prongs are the position must be paid on a salary basis, the position must be paid a threshold amount, and the position requires the performance of certain duties delineated for the exemption, and the position requires certain levels of discretion. Now, this is a very simplified version of the test. In fact, you need to look at the specific exemption that you're trying to address to see what those duties and discretion requirements are. It's just sort of a generalized concept that these three prongs have to be met. One thing I recommend that you can do is the Department of Labor has a really great system where they publish these fact sheets. And if you simply go in to Google and print DOL fact sheets, and 17A is a good one because that lists the test for both, for the executive, the administrative, and the professional exemptions, which are the most common that we find.
Thanks, Catherine. The next question is, one moment, is can you go over the not-for-profit sales income threshold again?
It kind of goes back to just what I was talking about with respect to whether or not the Fair Labor Standards Act applies. So there's two methods. One is the enterprise coverage, and that's the 2 or more employees and the $500,000 in business activity. So generally speaking, most not-for-profits don't qualify under the enterprise coverage with respect to the Fair Labor Standards Act, and that's because they're not engaged in interstate commerce. Now, like I said, if you happen to have a not-for-profit that does have a gift shop or sells certain merchandise, then in fact they will be covered. So it's not the enterprise coverage that we look at for not-for-profits, it's instead the individual. And that's, as Chris was saying, when the individual is engaged in any interstate commerce, and that's the sending of emails, the paying of credit card bills, accepting credit card payments, that's when you get into individual coverage.
Thanks, Catherine and Chris. It doesn't look like we have any more questions, so we're going to go ahead and end the webinar there. Again, I want to thank Chris Schrader and Catherine Samara for being here from Schrader and Associates and Mallard Grodner. We really appreciate it, and thank you again. And we will be sending out this recording to everyone so that they have it, so they can go back and play it again if they have more questions. Thanks so much.